Hello, and a very warm welcome to the third episode of the Money Side Up podcast. Thank you very much for joining us today. This is the podcast covering all things money for Aussies all over the world. Expats in Singapore, Australians back home in Australia, from tax to investment planning, budgeting, investing in property, trust the right structure. We've got it all covered on this podcast, and a very warm welcome to the third episode. I'm Jarrad Brown, Australian expat financial planner here in Singapore, and joined with me today is my friend and colleague, Joel Kerin, down in Perth. Good day, Joel.
Hello, Jarrad. How are you?
Not bad at all. How are things in sunny Perth? I've been watching the weather.
Well, I suppose if anyone's tuning in from Perth, you've probably appreciated that we've spent a lot of time indoors in the climate-controlled comforts of, our offices and our homes, as the thermostat, particularly over the past couple of weeks, has not sort of bounced below 39 sort of most days. So it's, we don't have that lovely Singapore consistency that is probably 32 and 90% humidity most of the year round.
That's the one. High chance of rain at 4 o'clock. It's pretty predictable and we love it. I think my blood is far too thin to spend winters in Australia, and 39, 40, goodness me, I definitely do not miss that. So I'll stick to my climate-controlled air conditioning inside in Singapore in the 32 degree, knowing that it'll be 32 degrees when I wake up in the morning and 32 when I go to bed. Much happy with that. Look, before we get into the podcast today and plenty to cover, we've got a great guest speaker as well that we'll be interviewing. Joel, let's cover off our disclaimer and keep the legal team happy.
For sure. So just so you know, everything that we cover inside this podcast is purely for our entertainment purposes only. It does not constitute financial advice, and it should be taken only as general advice. If you would like personal financial advice, please get in contact with either Jarrad or myself, and we'll be happy to provide you with financial advice that is tailored to you.
Wonderful. I guess now that we've got that one out of the way, there seems to be a lot going on in the headlines at the moment, and gee, I feel like there's a lot we could cover. We've got negative gearing back in the headlines. That always seems to rear its ugly head as we get anywhere near elections. We've got these stage 3 tax cuts, whatever they may look like, all sorts of things. We've got headlines around markets. Maybe let's start, Joe, with the tax cuts. What do they mean? What are expats need to be thinking about with these tax cuts? What could they look like in July? And I guess what's changed?
Yeah, sure. So the stage 3 tax cuts originally were announced by the previous coalition government, and they essentially abolished, the big part of this. They essentially abolished 37% and the 32.5% tax bracket. And they replaced that with essentially a flat 30% tax for a big part of what ordinarily Australians, on middle or higher incomes fall into, sort of over that $80,000 a year mark. And that would go all the way up to about $200,000. So this obviously tried to address what is known as bracket creep. And so bracket creep is, as inflation and the cost of goods and services and wages growth happens, naturally we start to tick up into higher tax brackets. Now, under the current tax brackets that we sort of know about, these haven't been changed in probably over a decade. So the government, or the previous coalition government, really wanted to address that bracket creep, and I suppose depending on what news article or what newspaper you were reading at the time, it just had either very positive or negative connotations around who's actually getting the tax benefit. And to an extent, high income earners, say anyone earning over 200,000 Australian dollars a year, which if we look at that sort of data that comes out of the Bureau of Statistics and the ATO, that sort of sits at probably the upper echelon. So that's the top 3% of wage earners in Australia. They were going to receive the healthy end of the stick of that tax cut, circa about $9,000 a year in a tax benefit. So following obviously lots of negative press and media and just changing market conditions, when obviously the coalition brought this in, in 2019, that's obviously pre-COVID. We're in a sort of different economic environment to what we were back in 2019 for sure. And they just wanted to address a couple of things. And particularly, we'll see what the full extent of this really looks like in the budget, which is due to come in to effect or to be spoken about, in April, May this year. So we're going to be, essentially they've essentially retweaked the stage 3 tax cuts so that everyone benefits from some sort of tax relief and not just anyone earning over $45,000 a year. So what we're starting to see now is that first tax bracket is being reduced from 19% tax down to about 16%. There's still debate, and it's mused that they want to tweak and alter the tax-free threshold. It currently sits at 18,200. That may increase. I suppose once we see the legislation come in, we'll know for sure. And then the Labor government has reintroduced, obviously, that mid-tier 37% tax bracket back in. So essentially trimming some of the tax savings at the top end and gifting it to and equalizing it out, let's say, to anyone on lower incomes. So that just gives us, I suppose, a high-level overview of what the stage 3 tax cuts are. I think, broadly speaking, it's a very positive thing generally. Australia is a very high tax jurisdiction. And, when we were talking about this, stage 3 tax cuts and what that means for particularly Australians and Australian expats, well, usually if you're an expat, you're a bit immune to not paying Australian tax rates. You're paying nice, comfortable Singaporean tax rates or Hong Kong tax rates, which are obviously much more favourable than Australia's personal income tax rates. So, it broadly is a good thing for Australians working here. There is still, I would say, an incentive to earn more money and to drive high incomes, particularly in Australia. But yeah, just not to the extent that it previously was.
Makes a lot of sense. Gosh, I really would hate to be a politician. I mean, the cost of living crisis is real. I'm a big believer personally in home ownership, and if you're a single parent or a single person trying to save that deposit, gosh, what a struggle. And hopefully these tax cuts will deliver some of that much needed relief. I do always worry when we start sort of tweaking with tax rates at the higher income levels that we're sort of putting a bit of a damper on innovation, and perhaps the top talent of Australia will simply go overseas where it's easier and more favourable, as you say, Joel, more friendly tax rates.
Yeah.
As we sit here in Singapore with the top tax bracket of 24% if you earn over $1 million. But again, obviously always a juggling act in Australia, and I guess part of that tax rate is the wonderful lifestyle that that you get to enjoy in Australia, and why so many expats will one day be back in the country, whether to work or to retire.
For sure. I think that you've sort of hit the nail on the head. Lots of high income earners in Australia historically probably have left. And, is the government here trying to incentivize people to come back or reintroduce that, top talent, skilled labor, particularly in Australia, that will derive a return? I don't know. I think there's still got to be more that can be done because lots of people do see that tax figure at the end of the day.
Absolutely. Yes, lots of expats returning and wondering when the Australian Tax Office worked half their shift. All jokes aside. Look, let's move on to, I guess, what's happening with the markets. We've seen the S&P 500 crack 5,000. We're seeing some interesting headlines around China, around Hong Kong. Broadly speaking, markets have been pretty positive, but it definitely looks like the top end of town in the US is really doing a lot of the heavy lifting. The S&P 500 at the time of recording this, so around mid-Feb 2024, broken through 5,000, up about 6% year to date. The Aussie market, the All Ords, or the ASX 200, relatively flat. up about 0.5% year to date, which is, I think, understandable. Obviously, when we look at UK, Europe, again, quite soft. Singapore market down a little. Again, a lot of Singapore made up the banks and property, which has certainly still been under pressure. Commercial vacancy rates still very high. A lot of people still working that sort of hybrid. Part of their week is at home, part of it's in the office, part of it's off-site. So again, a lot of those commercial landlords are struggling, particularly to fill older buildings. But I think the big one, front of mind for so many, and Joel, you and I were discussing this earlier, is the Hang Seng, down 6% year to date. Is there more to come? What's next for China and Hong Kong?
Yeah, so I was recently reading this article, and it was just sort of giving a broad overview of sort of what's happened in Hong Kong and China generally, over the past close to 30 years, realistically. So we see sort of the Hang Seng Index, when Hong Kong was returned to China in 1997, the Hang Seng Index sat at about 15,000, circa, close. Now, today, that Hang Seng Index is sitting around 15,000. Now, it's had a pretty bumpy ride up and down over that sort of past 30 years. But as we roll out into the new year, it's softened again quite back. Again, the index is down 6.21% currently year to date. So I suppose depending on what side of the glass you look at, if you see as an optimistic time or a pessimistic time, there are articles out there that say that Hong Kong's done. We're finished the Chinese market. It's really sort of softened it. But I suppose if you're an optimist, that could be seen as, where that turnaround comes, and what does Hong Kong and the Chinese economy really look like in the next, say, 5 years, 10 years? Are we still sitting at the Hong Kong and Hang Seng Index sitting at 15,000 still? Well, I suppose time will tell, right? And once I find my crystal ball, I'll be much happier.
Absolutely, it's definitely an interesting one, and look, I mean, I think from my perspective personally, I think there is some value there in China and Hong Kong, and look at all of the sort of long-term economic forecasts, and China is expected to be either 1, 2, or 3 in terms of the world's largest economies. So, not having some exposure there does seem a bit counterintuitive. Is now the right time? Well, as you say, Joel, let's dust off the crystal ball, and in 10 years' time, we'll be able to answer that question. But I think it also highlights, we talk to a lot of Australian expats saving money for their kids and even just for their own retirement. And it just so critically highlights the importance of geographical diversification. The same could have happened to Australia, to the United States, to India, to a lot of global developed markets over this time period. Now, it hasn't, and that's a wonderful thing for so many investors. But to start investing, as you say, 97, so 27 years ago now, or nearly 27 years, that's gone nowhere. And even throwing some dividends, you would have been better off with cash in the bank. You're probably lucky to have broken even on that investment. So definitely highlights the importance of not just diversifying across different companies, but diversifying across currencies, across regions, across sectors, and of course, asset classes as well, because 26, 27 years time, that is an ugly, ugly return. And what goes down doesn't necessarily need to go up. And the other thing I think a lot of investors need to realize is the Hang Seng does not owe you anything. It doesn't care if you invested when the index was 20,000 and it's now 15. It's now 15. That is the framework for you to make that decision. So, gosh, a very interesting one. Opportunities all over, and I think for a lot of Australian expats, obviously, China and Hong Kong, well, China in particular, being a pretty critical market to the long-term success of Australia's economy. Well, look, on that happy note, we're going to dive into our guest speaker interview today. Bit of a different topic today. We're focusing on estate planning for Australian expats in Singapore and outside of Australia. So we're interviewing one of the top estate planning lawyers right here in Singapore, covering everything from temporary and permanent guardianship for your children, what to do around long-term trust planning, how your Australian assets would be treated via a Singapore will, what powers of attorney look like between Australia and Singapore, and a lot more. So stay tuned for this interview. Really looking forward to introducing Andrew to you, to all of our audience. So let's cross to our interview with Andrew and see what he's got to share with us today. A very warm welcome to our interview today with Andrew. Andrew is a lawyer with Fortis Law right here in Singapore. Huge thank you for joining us today, Andrew. We've got a lot to cover. We get so many questions from Aussie expats in Singapore all the time. What do I do about my will? Is my Australian will valid? What do I do with the kids? So many different questions. So I'm sure there's going to be a ton of value that we're going to get out of this interview today. And I'm sure everyone will enjoy it. I guess, Andrew, let's start at the very beginning. Tell us a little bit about why you decided to specialise in estate planning and why you enjoy what you do here in Singapore.
Thank you, Jarrad. Yeah, so I'm Andrew. I'm a senior associate at Fortis Law Corporation right here in Singapore. I'm a Singapore lawyer, and one of my key areas of practice is in the area of estate planning. I think estate planning lets us meet people from all walks of life. So I have very diverse clientele. We have local clients and foreign clients alike, including from Australia. So it's always interesting to meet people from very varied cultural backgrounds, different nationalities, and we work with them to secure their legacy. That's the whole point of estate planning.
Fantastic. Well, as I said, really appreciate you giving us your time today. I think we'll keep a lot of the questions relatively surface level because otherwise I think we'd probably never actually get back to our day jobs. So let's start with the basics. What is estate planning, and why should Australian expats actually care and pay attention to their estate planning?
Sure. So estate planning is the process of basically planning for your legacy. Okay, so estate basically refers to one's assets after death. So estate planning can include things like doing up a will, sometimes even you do a trust. And why should anyone with assets in Singapore should consider estate planning? So it's not just for Singaporeans. Even if you're an expatriate, you're from Australia, and you have assets in Singapore, then that a Singapore component to your estate planning would be essential as well. Right.
Fantastic. And I think you touched on a really important point there, that Singapore estate planning is not just for Singaporeans. So we're going to dive into a bit of that today. So I guess, again, let's keep it at a high level for now. Singapore compared to Australia, how do the estate planning laws differ? Are they the same? Are they different? I guess how do the two sort of compare?
Sure. Well, fortunately for starters, the laws between Singapore and Australia are not too different. Singapore and Australia are both common law jurisdictions. Both are member states of the Commonwealth of Nations. So the laws surrounding the broad high-level laws surrounding wills and the formalities are really broadly similar. The between Singapore and Australia. Now, of course, there might be specific nuances, specific local regulations which differ here and there, which is why it's good to consult a lawyer in the different jurisdictions to advise you on the specific local regulations which may be specific to Singapore or Australia, as the case may be.
Makes a lot of sense. So if we start sort of getting, let's go down the rabbit hole a little bit. So cross-border estate planning, you hear all sorts of weird and wonderful things. One will to cover both, or my Australian will is fine. What are I guess some sort of high-level tips when it comes to cross-border estate planning for Australians with assets, say back in Australia, and maybe some assets here in Singapore?
Okay. So if you have assets in both Australia and Singapore, our preferred approach would be to do up an estate plan, a will in Australia, and an estate plan, a will in Singapore as well. Two separate wills to cover two separate classes of assets. Now, of course, a common question we get is, can I already have a will done back home in Australia? Can I just use that in Singapore? The answer is yes. An Australian will is, of course, recognized in Singapore. You can probate it before the Singapore courts and vice versa. Singapore will can be probated before the Australian courts. So if your Australian will was drafted to say cover all my assets wherever situated globally, for example, that can be recognized in Singapore. However, there might be specific nuances which lead to the preferred approach that you should do a will for Australian assets and will for Singapore assets. Let me explain. So, for instance, you may have a locally incorporated business here, which might be governed by specific industry-specific regulations that a lawyer that's not trained in Singapore law may not be familiar with. Or to give you another concrete example, for example, if you have landed property in Singapore, landed property in Singapore outside of the Sentosa Cove area, for example, may only be owned by Singapore citizens. Foreigners in Singapore can own landed property if they have obtained approval from our land authorities. So, assuming, let's say you were a foreigner with such approval and you pass away, your next of kin may not be eligible to hold on to said property, you see. So such a nuance may not be immediately apparent to a non-Singapore lawyer who prepared a global will. So having local expertise drafting locally crafted wills has that advantage of being able to catch certain nuances which a generalist drafting a catch-all global will may not be able to identify.
Absolutely. Yeah, such an important point. So obviously you mentioned wills, having a will in Australia, having a will in Singapore. What other documents, are there other documents that Australian expats should be thinking to put in place here in Singapore?
Well, besides a will, of course, you can consider some individuals consider setting up trusts. The trust, of course, trust can be incorporated into your will. That's known as a testamentary trust. Or you can set up a trust inter vivos in your lifetime, what we call a living trust, to place assets, settle assets into the trust while you're alive. That's a possibility as well. And of course, importantly, you see a will takes care of your assets after you pass away. Now, what happens if you don't pass away but you lose mental capacity? Then there is another document called the lasting power of attorney. In Australia, the similar term would be the enduring power of attorney, EPA in Australia. In Singapore, we call it LPA. Broadly similar concepts. So the LPA is basically to cover decision making in the event that you one day lose mental capacity. So if you get into an accident and you are in a coma, then your LPA can be activated such that your appointed donees, for example, next of kin, can friends and family who you have appointed can make decisions for you. Yeah.
Such an important one, and I think we see so many Australian expats ignore that. They come in, they get their will done, they think they're covered. But yeah, we've had a number of friends and clients. Having been in Singapore for 11 years now, they were out riding their bike, hit by a car, hit by a bus. What happens if you're in that awful situation where you don't pass away, but you've suffered that mental incapacitation? And obviously by the time that happens, it's too late to then go back and set up these documents.
Yes, you should always do it. While you're healthy, you see. Especially, I know Australians love the great outdoors, so they do a lot of physical activities that sometimes can lead to accidents happening.
Most definitely. So you've mentioned earlier an Australian will can be valid in Singapore, a Singapore will can be valid in Australia. I guess for an Australian expat, they've got their will in back home in Australia. Is there anything they need to do to make that will valid if they don't want to go through the process of having a separate will in Singapore?
Okay, so I'm assuming the Australian will is drafted generally. It's not confined to Australia only assets. It's catch-all. In such an instance, the catch-all will can be valid in Singapore. So upon death, there are two ways to go about it. One, the will is sent to the Singapore court to obtain the grant of probate directly, or if the Australian will has already been probated by the Australian courts, the Australian grant of probate, the grant of representation, can actually be resealed in the Singapore courts. So Commonwealth courts have this reciprocal agreement where the grant of probate in one Commonwealth jurisdiction is resealable in the court of another.
Okay.
So Australia, Singapore, New Zealand, the UK, jurisdictions like these.
Okay, that makes sense. Now you touched on earlier owning property, Sentosa, various approvals required for foreigners to own property. So let's just say an Australian expat, maybe they're a citizen in Singapore, maybe they're PR, maybe they're here on an employment pass. But in whatever way it's transpired, they own property here in Singapore. Now, obviously, there are different ways you can own property, joint tenants, tenants in common. When it comes to our will, our estate planning, what do we need to think about with these different forms of property ownership?
Okay, so in Singapore, there are you can own property as a sole owner or as joint owners. Okay, so sole owner, I think we understand you own the property solely in your own name. So in the event of your passing, your property can be bequeathed to your beneficiaries as per your will. Now, what happens if the property is jointly owned? So for joint ownership, there is joint tenancy and there is tenancy in common. So for joint tenancies, two or more owners collectively own the entirety of the interest in the property. There is no shareholding to speak of. So upon one owner's death, his or her share in the property disappears, and the other surviving joint tenants continue to own the property. So the last man standing, the last surviving joint tenant becomes the sole owner of the property. Therefore, the property will only fall under the will of the last surviving joint tenant. So, just to illustrate, if a husband and wife own a property and husband passed away, the wife is the surviving joint tenant, the wife now becomes the sole owner of the property. Therefore, husband's will would not cover the property. Only when the wife subsequently passes away as well, the property will then fall to be distributed under the wife's will. This is how a joint tenancy works, what we call the right of survivorship. Now, there is another manner of holding called the tenancy in common, where each owner holds a fixed share of the property. Let's say a 50% share, a 20% share, 30% share. This respective share of the property may be given away under your will. So if Jarrad and I own a property and I'm a 10% owner, upon my death, I can give 10% of the property away under my will.
Yeah, makes sense. Very clear. So I think certainly if people are buying property, it's really important to give that a bit of thought, obviously, before you enter into that transaction, how you want to own it. Let's talk about, I guess, probate, what actually happens if you have an Australian will, a Singapore will. How does all of that actually transpire? What does the executor actually have to do when somebody passes away in terms of that grant of probate?
Sure. So basically, the executor's first role, executor is the person appointed under the will to handle your estate after your death, okay? Because in the common law jurisdictions, unlike civil law jurisdictions in Europe, the estate needs to be administered by an executor, okay? It doesn't devolve automatically to heirs, unlike in continental Europe. So the executor first has to apply to court for the grant of probate, produce the original will, produce the death certificate, and then once the grant of probate is issued, the executor is then authorized to execute the instructions in the will, be it calling in assets, distributing it to beneficiaries, things like that. Now, if the executor is applying for the grant of probate in Singapore, then the executor needs to produce the original will to the Singapore courts. If the executor, for example, has already obtained a grant in Australia, like let's say in Victoria, Queensland, New South Wales, that respective court order can then be resealed before the Singapore courts. So it really depends on which way they want to go about doing it. There is no hard and fast rule for this. It really depends on what stage they come to us. Sometimes because the deceased passed away in Australia, perhaps it's more convenient for the Australian-based executor to first execute Australian assets, and then subsequently with the Australian grant, they contact Singapore and say, hey, my late father had assets in Singapore. We have the Australian grant. Okay, then Singapore will reseal the grant apply to reseal the grant for the executor. So that's that. Yeah.
Now, you mentioned there a few times presenting the original will. And gosh, if I had $1 for every time a new Australian expat client has said, I don't know where it is, but I know what it says, that is not good enough. I think
that is not good enough.
Clarify.
At least in Singapore, I'm not too sure on the position in Australia, but in Singapore, the original wet ink hard copy will needs to be presented to the family courts for the application for the grant of probate, as the present law stands. Because would it change in 10 years? Possibly, I don't know. But as the present law stands, the original hard copy will is required. Maybe in the future we'll all do QR code. I don't know. QR code wills.
Of course. Yeah. Look,
I mean, that's very possible on the horizon, but not yet, not yet.
Yeah.
So while as things stand, the will is very important. You need to keep the original will safe. Otherwise, it will add a lot of hassle to the probate process. So let's say even if we have a photocopy of the will, we still need to go through a process of getting the court to bless the photocopy, admit the photocopy as being a representation of the original will, and then start the grant of probate. So if the grant of probate is step 1, and you misplace the original will, we have to start at step -1 first before we can get to step 1.
Okay. So make sure you know where the original is, and make sure your executor knows where it is as well.
Yes, of course. Keep it safe, but not too safe.
Right.
Executor needs to be able to retrieve the original will. Please don't bury it in the garden somewhere.
Very clear. So let's, I guess, have a look at a bit of a different side of estate planning. One of the other common questions we get asked is, what do we do with the children? So we hear these things about temporary guardians, about permanent guardians, quite often for Australian expats, and I'm sure many others. The permanent guardians might be back in Australia. It might be our parents, our brother, our sister, or friends or other family back home. So I guess what steps do we need to take? What things should we think about? How do we ensure our kids are protected?
So under your will, you can appoint a testamentary guardian. Usually this is structured to kick in only when both parents, natural guardians, are deceased. Of course, there could be exceptions. You might be a single parent with children in Singapore, maybe separated or widowed. There is a variety of circumstances, right? So the testamentary guardian would then assume guardianship of the children upon your demise, step into that parental role to have care and control, custody of the children. Now, of course, Jarrad mentioned a good point. Your testamentary guardian could be your parent or sibling who's back home in Perth or Darwin or Brisbane, and your children are here in Singapore going to school. What then? Okay, so it may take some time for the testamentary guardian to come to Singapore to make relocation arrangements for the children. In the meantime, if you have friends or family in Singapore, you can always appoint them as a locally based temporary guardian, just to provide some supervision over the children, care for the children, until such time that the permanent guardian is able to make the relocation plans to possibly either relocate to Singapore to live with the children or relocate the children back to Australia. It depends on how old the children are. If the children are going to high school, then you may have to make changes to schools and enrollment and things like that. Whereas if they were infants, then the consideration could be very different. Yeah.
Absolutely. And so on the temporary guardian, is that something that you should document, or is it something you have a chat with your mate down at the pub one Friday and say, hey, if anything happens, look after the little ones?
You should always have a chat with your mate at the pub. That's always the first step. So please do that. Please do that. Because you want the guardian to be acting willingly, and you want the guardian to be someone one of your good friends or so. But of course, beyond that, you should also put in formalize it in your will, so there can be no disagreement or dispute arising thereafter. Yeah.
No.
Because what if both parents pass away? Then in that vacuum, who has authority over the kids? At least if the guardian is named in the will, then the guardian can have at least some decision making capacity. At least even in the interim, it's better than nothing.
Of course, yeah, no, definitely. One of the other things we have in Australia is this kind of healthcare directive. Various decisions or things to think through as far as health and treatment is concerned. What is the sort of similar setup in Singapore? What should Australian expats be thinking about with this one?
Okay, so I think that the two related topics here. First, we talk about advanced care planning. So for advanced care planning, you can document your healthcare wishes, preferences, for example, surgery, pain, medications, vaccinations, chemotherapy. Everyone's preferences on these very thought-provoking questions could be quite different. So I suspect advanced care planning might be more advanced in Australia, as many Singaporeans are still a bit more taboo on this topic. There is still some cultural taboo on death and death, illness, suffering, and incapacity in Singapore. So we have some catch up to do with Australia. And then we also have the Advanced Medical Directive, in which you can pre-authorize a healthcare provider to withhold extraordinary life-sustaining treatment, but only under very restrictive conditions. Death must be imminent. You must be suffering from terminal illness, and you must be unconscious. Yeah. So under such circumstances, your AMD, we call it, Advanced Medical Directive, can authorize a healthcare professional to withhold life-sustaining treatment from you. Now, as I understand it, please correct me if I'm wrong, Jarrad, Australia, quite a number of states have liberalized laws on euthanasia to some degree. So Australia might be a bit more liberal in that regard. In Singapore, the stance of euthanasia is still fairly conservative. It's not legal yet. Yeah.
Okay, certainly something that I think Australians definitely need to give some thought to. Let's jump on to another topic, I guess. Different things we might own, businesses, different assets. Obviously, over the last few years, we've seen cryptocurrency, non-fungible tokens, all sorts of digital assets that are now owned by let's stick with Australian expats in Singapore. Is that something you just include in your will, just like a house or shares in a portfolio, or should you keep a separate record somehow of these digital assets?
All right. So conceptually, there's no problem with including cryptocurrency in your will. For example, I give all my cryptocurrency assets to my spouse. I mean, a line like this would have legal force.
Mm-hmm.
Now, the question is practically, how do you access the cryptocurrency assets? So you see, if I had bank account monies, I just take the grant of probate, show it to the bank gives me the money as the executor. Simple. Now, with cryptocurrency, we know it's not that straightforward because of blockchain technology and anonymity and things like that. So what you should do is keep a memorandum of your digital assets. So your wallets, your IDs, your passwords, things like that. That can be kept in a document. We refer to it as a memorandum of digital assets, but I suppose you can call it my Excel spreadsheet or whatever you like. And that document can be kept together with your will. Now, why do I not ask you to put these information into your will? Well, the simple answer is you wouldn't want me to know your cryptocurrency passwords, right? So these are sensitive, confidential information, even to the lawyer drafting your will, you see. So the professional, you wouldn't want even the professional doing your will to know your PIN numbers, right? So keep all this to yourself, keep it in a document. So only after your death, your executor can retrieve these assets for relevant distribution or monetization.
Some excellent points. I mean, we've met a number of Australian expats over the last sort of 3, 4, 5 years, where a small investment became quite a meaningful sum, relatively quickly. And I guess even if it's not a meaningful sum now, these are things that should be given some thought and recorded safely, securely, as you rightly point out, because who knows what something could be worth in a year or two, or some period of time where you forget all about that digital coin that you bought into, and all of a sudden it's the next Bitcoin or whatever it may be.
Yeah. So it's something to think for this one. That's a bit trickier from a probate perspective because there is no centralized authority which can it's not like a bank, you see, where I can always access the dead person's accounts with the relevant court orders. But with crypto, there is no central authority to give you access to something. We need that PIN or password, right?
Yeah. And so many different ways to store it, offline. I mean, gosh, we won't go down that rabbit hole, but
that'll be another 3 hours.
I think so. But one of the other common ones we see with Australian expats is, we're constantly presented with different investment opportunities. A friend starting up a business, starting up a bar or a restaurant, whatever it may be, and they buy these stakes. Maybe it's 5%, maybe it's 50%. What do you do with these stakes in a business, which is effectively private equity, when it comes to your estate planning?
Okay, So for this is a question of business succession, I don't think it's specific to Australian expatriates. So this applies to anyone who might be listening to this podcast. Well, if you invest in a business and you become, let's say, a shareholder of a private company, it's important to have a discussion with your fellow shareholders to say, what happens if one of us passes on? What becomes of our stake? Are you okay if this stake goes to my wife, my fiance, my children? Not all shareholders, from experience, not all shareholders will be comfortable with say, oh, I would dealing with the next of kin of and a shareholder. Like I might know you as a shareholder today, but I don't know your wife, so I may not be willing to cooperate with your wife in the company. See, so what a common mechanism will be a buy-sell mechanism in the shareholders agreement, such that upon the death of one shareholder, there is the right of first refusal. For example, the existing shareholders can compulsorily acquire the share of the deceased shareholder at a valuation or some other mechanism. And then that money goes back to the estate of deceased shareholder so that we can continue, the living shareholders can continue our business operations with minimal risk or disruption. So it's very important to look into shareholders agreement. Fatal flaw, many people start businesses or join businesses without shareholders agreements. That's a very fatal flaw and something to look into the shareholders agreement and consider incorporating relevant clauses relating to contingencies such as the death or incapacity of a shareholder.
Absolutely. I think you only really discover the importance of these documents when something's going wrong. When everyone's happy and the share price is coming up.
About it, right?
Absolutely.
Nobody thinks about it.
Look, that's really clear, very helpful. Again, let's flip this around a little bit. Australian expat, single, no children, couldn't care less where their assets go. Just here for the now. Don't maybe don't have any brothers or sisters. Just don't really care about leaving an estate. Should they just not worry about their will, their estate planning, or are there things that even those people should be mindful of?
Oh, they can will it to me. I'm just kidding. Yeah, well, that's the joke when the clients tell me, oh, who should I give my assets to? I don't know. I'm like, you can give it to me. That's just a joke. Okay, to lighten the mood. Well, so on a more serious note, the if you're single, it's okay. That's one question we can never answer for you. Who should my assets go to? Do you want to leave it to? Do you have friends? Do you have a significant other? Do you have charitable causes you wish to benefit? There's some variety of things that you can do. I mean, it's your money. You can make something out of it, right? So even if you don't have family, because maybe your family are deceased or what, you can leave it to friends or charities. Yeah, that's fine. And more importantly, for expats who are say single legally but have significant others, for example, they have cohabitating living partners. It's important to do a will to ensure that your partner gets your assets if that's your intention. Because without a will, just to share, the default inheritance law, what we call intestate law, would apply. And so if you're domiciled in Australia and you pass away, Australian intestate law actually applies to govern the distribution of your movable assets if you don't have a will. Okay, if you have immovable assets in Singapore and you don't have a will, then Singapore intestate law will apply. So there is a disconnect for foreign domiciled persons with assets in Singapore. For the movable assets, we're talking about like bank account monies and things like that, shares. That's governed by the intestate law of your home domicile, so Australia in this case. But the real estate here will be governed by Singapore intestate law. There's the risk. But if you do a will, of course, then we can call that out later for us to do the distribution.
Okay, that makes sense. What about insurance policies? So, we are, as financial planners, we're big advocates in making sure, you've got your basics covered, your life, your disability, income protection, trauma cover. When it comes to our estate planning, particularly with the life insurance, what should we be thinking about? What documents should we have in place? How does this all sort of connect to our will? Does it not? Again, what are some of the, high-level things we should give thought to?
Okay, so for life insurance policies, there is usually the option to make a nomination Okay, unless of course if the insurance policy is bought with financing from the bank, then that's not possible. But I'm assuming here for regular not unencumbered insurance policies, you can make a nomination. So what happens with a nomination is that upon your death, the nominated beneficiaries can receive the payout from the insurance company without the need to probate the will. So the advantage of that is speed. So let's assume you are sole breadwinner, you pass away, your wife and children, assuming they're nominated beneficiaries, of course, can get the quick cash to tide them over while your assets are still going through the probate process. So that's the advantage of a nomination. Of course, there are drawbacks to that too. Some people might prefer, especially the death benefits are a huge amount. Some individuals might prefer that no, I want this inheritance to be distributed according to conditions or in a staggered fashion to my beneficiaries. So that they may want to impose conditions or before children get inheritance, they may want to have age requirements, they may want to have a staggering so that beneficiaries don't get too much money at one go. So under such if there are such considerations at play, then it might actually work to not do a nomination. Without a nomination, the death benefits fall back to be distributed under the will, and your will would have had state clauses that I mentioned to govern the distribution in accordance with your wishes. So nominations are good, but they're not always appropriate. It really depends on the intentions and the circumstances.
No, very important, because I think a lot of whether it's insurance agents or advisors or just expats in general think, yes, okay, nominate a beneficiary, but yeah, what if that is your child and they're getting $2, $3, $5 million? That's probably not going to be the best thing.
Do you want a 21-year-old to have $3 million? Where would you spend it on?
I'm sure the 21-year-old will be very happy.
Yeah, the nightclubs will be very happy too.
Absolutely. Not a recommendation to invest in night funds, by the way. Let's just clear that one. Look, let's have a look at some of the more common mistakes. I mean, we are not solicitors and we hear about them all the time. What have you seen some of the biggest blunders, the most common mistakes, particularly as it relates to, I guess, Australian expats or even expats in general, when it comes to getting things wrong, missing documents, not thinking about something? Give us your sort of thoughts and insights.
Well, okay, such mistakes perhaps are not unique to Australian expats or to expats in general. It's just across the board. First of all, procrastination. I've said so many times I've been called upon to do death big wills. People dying and say, "Oh, please, I need to get my will done." Then of course, I'll be like, "Oh, you should have done it 10 years ago." So it's a scramble. It's stressful. Everyone is frantically trying to piece the will together, confirm that the testator has the capacity to instruct on the will, and then it's a scramble rushing to the hospital, especially during the COVID era. I tell you, it was a nightmare getting in and out of hospitals. There's so many procedures before they even allow you admission to a hospital or to a nursing home during the height of the coronavirus, especially. So don't procrastinate. That's the first pro tip I can give you. Get it done while you're healthy, while you're alive. Don't wait till it's too late. But of course, both the death big will cases are the lucky ones. They actually got it done. There are some cases where tragedy strikes and it's too late. Then they couldn't do a will, and then the next of kin sometimes are left struggling, perhaps because due to for example, if the intestate law might not have been what the deceased wanted, due to fractured family relations, and then there is what we call sometimes in legal parlance called the laughing heir, where because the heir who inherits is perhaps estranged from the deceased, but due to a stroke of luck, the deceased not doing planning, then the heir inherits. So usually, you're supposed to be grieving after one's death. So they determine the laughing heir because he's not sad about your death, but laughing at the windfall, you see. So that's something we want to avoid as well.
Absolutely. Yeah, gosh, most definitely. A lot of things that I think a lot of people won't have thought about, or just don't even understand are possible. So, I mean, I guess if we look at the Australian expat, they've moved to Singapore, maybe they've got a will back in Australia, maybe they've got some documents, maybe it's one of those, I know what it says, I don't know where it is, or maybe it's I did it 10 years ago, but since
I
then
forgot what it says sometimes.
oh my God, or I've had a couple of children, or I've been divorced. How does one actually go about updating their will, maybe revoking, what should Aussie expats be thinking about?
Okay, so it's always important to sit down and consider every time there's a major circumstance, life changes in life circumstances, family circumstances. I think that's one. So marriage is the most obvious one. Under the Wills Act, your marriage revokes wills done prior to marriage. So if you did a will as a happy single at 25 and you got married 5 years later, that 25-year-old will is revoked automatically, and you have to redo a new will. There are other circumstances which warrant you reviewing your existing wills, for example, even though they may not be revoked by law, but you may want to strongly consider revoking and redoing. For example, you have the birth of new children, divorce, of course. You may not want your ex-spouse to benefit, although sometimes ex-spouses can still remain friends. I mean, there are many kinds of cases out there. You have a death of a family member, souring of relationships in the family, things like that. There's always every time major changes in relationship structures, life structures, life circumstances. I think that always warrant you to sit down and consider whether you should review your will. It's not something you need to review on a weekly, monthly basis for sure. But I mean, people ask me, is once a year, once in 5 years, what's a good timeline? I'm like, there's no fixed timeline. It really depends on how your life circumstances evolve. If you have, I've seen cases where a will done 20 years ago is still fit for purpose today because nothing much has changed. If so, that's great. Yeah, then that's fine. But it's always good to apply your mind and consider whether a need for updating arises. There's no expiry to your will. A will done 50 years ago is still valid today, assuming there's no other operation of law that revokes your will. The marriage example being one. So, yeah, but it's always good to sit down and see whether it's still fit for purpose. Yeah.
And I think I'll just reiterate a very important point that you just made. Marriage revokes a will, and just make sure we've got this right. So getting married will automatically revoke your will. Getting divorced will not.
No, it doesn't. So if you had willed everything to your spouse, you got divorced, and then you die a day later without changing your will, congratulations. Your inheritance perversely goes to your ex-spouse, which may not necessarily be what you want.
So definitely, I mean, there's a lot of gold we've touched on today in this interview, but I think that one, if nothing else, you have friends that are getting divorced, neighbours, colleagues, whoever it might be, definitely raise this with them, because I think a lot of people automatically assume, well, they're not my husband or wife anymore, so they're out, which is not the case.
Not the case, yes.
Look, let's I guess give people a few parting tips. As we said earlier, I think we could be here all day otherwise. I guess as far as general resources, there's so much more than just drafting your will or doing a video recording of I want my staff to go to person ABC. How does the average Australian expat sort of access information? Is there a book, a website, or what should they sort of access to just to start to sort of, I guess, wet their beak a little bit, get a bit of an insight in terms of what they should be thinking about?
Well, fortunately, there are actually multiple websites, links online. You can search on Google, which talk about the basics of estate planning in Singapore, the introduction to wills in Singapore 101, introduction to lasting powers of attorney, things like that. Our own law firm, our LinkedIn page has several articles on legal issues, including estate planning. But we write about other things too. You're welcome to read. I contributed quite a number of articles to that database as well. Of course, that's for initial reading. But if beyond that, always speak to a lawyer, speak to an estate planner. Have a consultation and find out what options are suitable for you and your family.
Makes complete sense, and I'll make sure that they'll get a link to the LinkedIn page so people have got that. They can access website resources from Fortis Law. I think that's very valuable for a lot of people just to start get their head around what they should be thinking about. Now, one of the questions we're always asked as a financial planner is, when should I come and see a financial planner? So let me throw this one to you. When is the right time to get your estate planning in order?
Now, today. Okay, I mean, get it done. There's no right time to start. You don't have to wait till you are 16, it's good to start young. Then you can, because death can strike us at any time. Yeah. So fortunately, death is less taboo in Australia than Singapore. So I can say with greater confidence. Yeah. So it's good to plan early. Yeah. So as you can just we don't want to rush through the process. Estate planning is a endless. It's a ongoing process, but you can get started. Then we will see what works for you. Then what works for you today can perhaps cover you for 5-10 years down the horizon. Then maybe 20 years later, when your kids grow up and you have grandkids, then we can always tweak and adjust things along the way. It's an ongoing thing, similar to financial planning. Right? People don't look at their insurance policies every night, of course, but it's something they sit down and review every now and then.
Absolutely. Yes, definitely.
It's a bit like going to the doctor for your checkup once in a year or 2 years. So
of course,
you don't go to the doctor every day, right?
Yeah, I'm sure the doctor might be happy with you doing so. Or might get a bit sick of seeing you. Look, one of the questions we love to ask our guest speakers on this podcast is that one golden piece of advice. I mean, I'm sure there's a lot you could cover, a lot you could advise people on. What's that one golden nugget, if you had to boil it down to just one thing to share with our audience, Australian expats in Singapore when it comes to their estate planning?
Well, I think it's important to secure a legacy. There's no reason not to. It's not, the cost of estate planning is reasonable relative to, the benefits. It's your assets accumulated over your lifetime, and it's about providing for your loved ones, your next of kin, your friends, your family, or supporting causes that you might champion in after your death. So since this is your hard-earned money and assets, put it to good use in however way you deem fit, of course.
Absolutely. Well, look, Andrew, we might wrap it up there. As I said, otherwise, I think we could just continue talking. And what if I own this? What if I own that? Divorce, marriage, all sorts of other scenarios. But look, a huge thank you for joining us today. You've given us some wonderful information to think about, some hugely helpful tips, resources. We'll make sure your details, the company's details, are in the notes. So anybody who wants to access those can obviously find them. But as I said, huge thank you for giving us your time today. And I'm sure we'll have to have you back on and talk through some different scenarios for Aussies in Singapore.
Sure. Thank you. Thank you, everyone.
So thanks so much for tuning into that interview there. I really hope that you've gotten a lot out of that. So this marks our third episode, and we'll be continuing to release one episode each month. We'll be interviewing an expert each month on topics ranging from determining the right time to repatriate to Australia, how to update your estate planning as an expat, etc. The podcast is on all major hosting services, so you'll be able to find us, subscribe, check out any of the resources we're creating as part of this podcast, and of course, please leave us with your questions. If you have any questions, send them through. We would love to hear from you.
Thank you, Joel. So as said, if this appeals to you, if you like it, leave us a 5-star review. That would be wonderful. Tell your friends, tell your family, tell your colleagues how you've heard about it. Obviously, we're not selling anything on this podcast, nor will we ever be. So if you're getting value, please do share it. And of course, don't forget to check us out on our social channels. We're at Money Side Up on Facebook, LinkedIn, Twitter, or X, depending on your preference. And of course, Instagram for now. But I'm sure there will be more to come. Next month, we have got a US tax expert covering all things US tax for Australians and all things Australian tax for Americans. So don't miss that one. It's going to be a lot of fun. Plenty to cover there. But thank you very much for tuning in. Thank you, Joel. Looking forward to seeing you on the next one. Have a great week, everyone. And see you all soon.